The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
Hi everyone, welcome to another edition of Eye on Oshkosh. I'm Cheryl Hentz along with my co-host Tony Palmeri, and our guest this evening, we're very pleased to welcome to the first time ever that he's appearing on Eye on Oshkosh, Assistant Winnebago County District Attorney Mike Balskis. Mike, thanks so much for being here.
Well, thanks for asking.
We appreciate it. We're having you on for a couple of things. Primarily, you know, you've been pretty involved in some of the ongoing Joe Paulus stuff, and ever since he was, you know, sentenced to his prison gig, we've not heard a whole lot about things other than that he was appealing the sentence and that kind of thing. So you wanted to kind of bring us up to speed on what's going on with that, and then we're going to talk about some other things that are going on with respect to the county and the judicial process. But where are things at with the Joe Paulus thing? Now, he was sentenced to, was it 58 months in prison?
It was 58 months in prison approximately 1 year ago.
Okay.
And what's important to note is that what he was convicted of was 1 count of racketeering based on 22 counts of bribery and 1 count of income tax evasion. So that means that in terms of the state charges that could be brought against him, he could be charged with all 22 counts of bribery plus any others that are discovered. He was sentenced to 58 months, which was over the guidelines, the federal guidelines at the time. That's under appeal, but right now he's in prison in Pensacola, Florida. In the meantime, after that occurred, well, maybe I should back up, is that when I first got here, and that was January of 2003, Bill Lennon was trying to have an investigation done by the Attorney General's office. Previously, he had asked Attorney General Doyle to do an investigation. He refused, saying that it was all political. Then he was asking the Attorney General to do an investigation. That was not done.
And that was Peg Lautenschlager then,
That's
correct?
correct.
Okay.
And then really how it started coming about was that Joe Paulus' defense attorney went to the Attorney General's office and said, let's make a deal. Let's wind up everything. Let's wind up the state charges and the federal charges together. At that time, Bill Lennon had contacted the Attorney General's office again, said, you know, there has to be further investigation because it's not limited to just these 22 cases. We knew that there was more out there. We knew that it wasn't limited to just taking bribes. We thought that there had been serious questions raised in terms of obtaining convictions, other type of behavior that even went back as early as the late 1980s.
Let me just interrupt for a moment, Mike. You said that Paulus's attorney went to the state. His attorney is Frank Gimbel out of Milwaukee.
That's right.
At what juncture did he go to the AG's office?
He went shortly before Joe Paulus was going to be appearing in federal court.
Okay.
And at that time, he went to the Attorney General's office and said, let's talk about potential state charges, and their response was, what state charges? What crimes? They basically had no concept of what was going on.
Mr. Gimbel apparently felt that there was maybe something coming down the pike. I mean, would that be a good guess?
Well, he knew that the state could charge the individual bribery counts.
Okay.
That he knew that they could charge a variety of crimes. So he wanted to make a nice little neat package. What happened was that Peg Lautenschlager said she was personally going to recuse herself from handling the case because she was the one who actually hired Joe Paulus as an assistant.
Right.
Bill Lennon had said, well, he was personally going to recuse himself. Really, he didn't have to because I don't think there would be a conflict. But he said it might look better for someone else to handle the matters. So he asked again for the Attorney General's help. And he put me in charge of the issues dealing with our office with Joe Paulus. We had a meeting with the Attorney General's office, and we spoke for almost 2 hours, dealing with other issues besides bribery. And I think they were shocked at the scope of what this investigation would entail. So they decided, well, we can't make a deal at this time. We're going to have to look into this further. And basically an agreement was made that they would do most of the criminal investigation. We would, in our office, handle some of the claims that were coming in, try to separate any valid claim from something that wasn't valid, give it to them, and that they would do their investigation. There was also an attempt to get the records from the federal authorities, and that was some problems because for some reason the federal authorities didn't want to share their information with us or the Attorney General's office. We then petitioned, well, the Attorney General's office petitioned for that information. We were told that we would get copies when that occurred. They got permission to get all the files in November of 2004. And when they got their files, they basically said that they would not share them with us, the local office. So we got permission from the federal court to allow us to be part of the secrecy order. And again, the Attorney General's office has refused to share these files.
Okay, this is
Why do you
interesting,
think
Mike,
that
because,
is?
well, because Lautenschlager has an assistant attorney general named Hanrahan working on this, right?
Well, actually, Bill Hanrahan was, see, this is part of the problem. Bill Hanrahan was the first person who was assigned to handle the case.
All right.
I've got to say, he was very aggressive, and he was of the view, let's not wait to get the federal records. Let's go, let's find everything out. Then he got promoted to become the head of the Medicare fraud
Oh,
unit.
so he's
Wow.
off this case now.
So he's off the case.
Because it said, he was quoted as saying that he would vow to determine, or he vowed to determine how far the tentacles of corruption have reached into the criminal justice system in Winnebago County. So who succeeded him?
An assistant attorney general, Gary Freiberg,
Okay.
and Ray Cordy were the two individuals that were assigned to this.
Have they not been as aggressive as Hanrahan?
Well, one of the things which is unusual, I thought was unusual, well, Bill Hanrahan said, I want to start, I don't care if we have the federal records, we're going to start, we're going to look into these things. After he left, they basically said we're not going to investigate anything until we get the federal records.
And why
federal
is it that you
reports.
think that the feds will not share their records? I mean, you're all supposed to be on the same team, is the way I think most of us look at it. You're all prosecutors.
Right. Well, I think at first, part of the reason was, I believe, that I know that Mr. Lennon was critical because we knew that there was more things than just this bribery out there. There were serious questions about other cases. And what they did was they limited themselves to just Joe Paulus and Mitch Cheryl. You know, when I was a prosecutor in Chicago, we used to have a saying about the federal authorities that they won't prosecute a case unless you have a videotape and a confession. And essentially that's what they had with Joe Paulus, because Mitch Sherlin had videotaped and also taped Joe Paulus while working for the feds. And it's quite interesting because of what happened with E.J. Jelinski, that he could be taped again, but that's what happened. So in essence, they had a confession and a videotape of Joe Paulus admitting to these acts of bribery. They liked their cases nice and neat, so it served their purpose. They got the big fish, they went on. And they didn't look, they may have looked further, and they just didn't choose to file any other charges.
But it sounds like you're suggesting that Lautenschlager's office is stonewalling on this.
Well, they have not been very cooperative with
But
us.
why? What's your theory?
Well, they've given us mixed messages. One is they said, we are only going to go back 6 years, which is the felony statute of limitations.
Okay.
So then we said, okay, we'll look at things that are more than 6 years old. And the reason why we could do that is because those are relevant. There is a charge of racketeering in Wisconsin. Those could be charged. If you have predicate acts, and those are illegal activities that occurred even beyond 6 years ago, you can allege a continuing conspiracy. So we think they're relevant information. They have indicated that in one of our meetings, it was kind of interesting because I think they kind of caught themselves, because under Wisconsin law you have to have permission from the Attorney General's office to file a racketeering charge. But you don't have to have permission to investigate. So they were saying, well, you know, you can't file. Of course you can investigate. And we're like, that's right, we can investigate. But they have been very reluctant to share any information, even though now the federal courts and the U.S. Attorney's offices said we can have copies of those reports. They have not come forward and said, okay, here's a list of the 22 cases that we're talking about. Because in the pleadings in the federal case, it never said this specific case was a bribe case. This specific case is a bribery case. In fact, in our investigation, we have found at least several other cases which we are convinced are bribery cases. One of them, in fact, came up during the judicial election in Outagamie County. And it was clear that that case was a bribery case, and actually the statute of limitations is still viable for that case, for Joe Paulus and Mitch Cheryl, and possibly anybody else who was involved in that case.
Well, what would you say to the argument that Paulus is in jail? Move on. I mean, the Oshkosh Northwestern, I think, was it Rickman, said that Mike is a headline-seeking assistant DA or some nonsense. I can't remember what it was. So why not just move on? The guys, I mean, is the goal to get Paulus on more counts, or is the goal to uncover more corruption surrounding him? In other words, are you like casting a net for others?
Well, we really don't care what happens with Joe Paulus.
Okay.
He's serving 58 months. I mean, I think that if it's proven that he tampered with cases to get convictions illegally, then I think that's a different story. You know, then he probably deserves some more time. But we really don't have, I mean, he's got a substantial sentence. We are interested in everyone else.
Okay.
We are interested in other attorneys that may have given him bribes. We're interested in police officers who might have cooperated in terms of getting false convictions. We're interested in how this could have happened. I mean, you think about this. This was going on. You know, the indictment was only over a few year period of time. This happened. His behavior was going over for almost the entire time he was district attorney.
It's 14 years?
Right.
Yeah. And is it conceivable that in 14 years it was Paulus and Shearland? That's not conceivable.
No.
So there had to be others.
There had to be others. And actually, when you look at patterns of conduct, and you see patterns of conduct, and you can find out, and it's a tough process because now we have CCAP. And the problem was that Winnebago County in the year 2000, they went on CCAP, and so they backloaded everything. Well, the problem is they didn't backload all the information, and not all of it's accurate. So you just can't run a list and say, okay, give me all the lists of cases where Cheryl was the defense attorney, because you're going to miss quite a few. In fact, the case that we found, the William Rotho case, that was a case where Mitch Cheryl was the defense attorney. He was not listed on CCAP, but we found that out because he got picked up on another drunk driving case. We looked into his old case and found out that, wait a minute, Mitch Cheryl was the defense attorney. And looking into that further, we could see that that case was dismissed twice. You know, and we're fairly certain that that is another bribery case. Again, the amount's $5,000. You know, you talk about patterns. It usually was $5,000. We know that there were other cases where they were dismissed or amended for less than that.
Mike, you've been working on this for a while, so your working knowledge of it is very, very good. In your professional opinion, do you think that this could go even higher than other defense attorneys and other police officers, you know, that you've alluded to? Can it go higher than that?
Well, I think it could, not only for illegal behavior, but also I think one of the questions that has to be asked is, why wasn't anything done? You know, why wasn't he reported? Who knew what and when did they know it? You know, that's a question that's always been asked. But it's clear that if you look at, there was, you know, you look at the system, and I reject, there's some people who say, this wasn't a system failure, it was an individual failure. That's wrong.
Yeah.
The system broke down. You had Judge Key and Judge Hazy write a letter to the Board of Attorney Professional Responsibility questioning the fact that Cheryl was on the local board governing the behavior of attorneys and saying, we think this is a problem based on the allegations with Joe Paulus. We ask you to look at that. The board sends a letter back saying, nah, we don't see any problem. And Judge Hazy writes back a letter quite pointed, comparing the, you know, the fox guarding the chicken. You know. But here are two judges who took an effort. Judge Carver took an effort to try to do it. And if you look at, for example, Judge Carver, he made an effort. And of course, he was attacked, you know. And Joe had a way of doing that. For example, the drunk driving cases. You look at those. Right now as an assistant, and I've been doing this for over 20 years, if I no-issue a case, chances are I'm going to have a police officer coming into my office and saying, what was the matter with this case? Why didn't you prosecute it? Well, you have over 20 cases which were dismissed or amended, drunk driving cases. Why wasn't people complaining?
Yeah. Along these lines, Mike, you were quoted in one of the papers as saying, one of the big questions is, why didn't people speak out? What we're finding is some people spoke out, you just mentioned some, and as a result they were harmed or damaged, either fired or threatened. Can you give us some more examples of people that were harmed or damaged or fired or threatened by speaking out?
In fact, with all the stipulations that were done with the drunk driving cases, there were many assistants who signed these stipulations. And basically, when you look at the police reports, compare the stipulations, they shouldn't have signed those. And that's an ethical problem that they're going to have to deal with. There was one assistant, only one, that stood up and said no. Her name was Carissa Keeker. And Carissa, she was a former intern when I was in Outagamie County, and she was a very capable, very good attorney. Well, Joe went in one day and said, I want you to sign this stipulation, amending and operating while under the influence to another charge. She said no. She said, ethically, I can't do this. So basically, Joe made her life terrible. And he punished her whatever way he could in that office setting. What he ended up doing is taking that stipulation, going back, giving it to another assistant who just signed it and filed it.
Who signed it, out of curiosity?
That case was Rob Sager.
Okay.
Did she end up leaving the county?
Well, she stayed. She ended up leaving actually after Bill Lennon got here because she got married, and she's
Okay.
now living in Colorado. So
And where's Rob Sager at today? Is
he's
he
in
up-
Outagamie County.
I was going to say, I think he's up there.
Okay. You also said that you were going to look at the high-profile cases, and one of them was the 1990 rape case against Mark Peterson,
Yes.
in which Paulus allegedly concealed information about the key witness that cast doubt on the witness's credibility. Shortly after Peterson's conviction, the verdict was set aside. He was never retried. What has happened with this Peterson case?
Well, the Peterson case, it's fairly clear that one of the allegations in that case was that Joe Paulus was working on a book deal.
Right.
And actually, I think that we found evidence in the files that confirmed that he was trying to sell that story to someone. Of course, when it all tumbled down, that didn't happen.
Mm-hmm.
You know, see, part of the problem is that that's in 1990. You know, we've turned that information over to the Attorney General's office because we believe that that can be part of, you know, these predicate acts. This also shows a pattern of behavior.
Mm-hmm.
Because in Peterson's case, you know, the allegation was that he knew of basically information that would cast doubt on the credibility of one of the main witnesses in the case. He hid it.
Right.
He didn't want it to be shown, and he said, don't. And what happened was that the victim witness coordinator at that time, now Sheila Berry, then Sheila Carmichael,
Right.
ended up being fired and let go. You compare that to other cases, and you see a pattern developing. We had talked before.
Yeah, Joel Samita.
Yes,
Samita.
Samita, I believe.
1992. He was. Let me just give some details for the audience. Joel Samita was held for rape and kidnapping, even after Paulus obtained DNA evidence clearing him. That's what the public defender John Keck said. Samita spent a year at the Winnebago Mental Health Institute before he was released. So you're fairly certain that Paulus did obtain his DNA evidence and withheld it.
Right. The DNA, the Stephen Avery case is in the news today. And this is different from Stephen Avery.
Just tell our viewers, Avery was the guy who was convicted of rape and then he spent 18 years in prison?
18 years in prison. They had found, at that time, the time of the offense, there was a hair that was found.
Right.
They could not perform DNA evidence at that time because the technology wasn't there.
Okay.
When mitochondrial DNA was developed, a test for that, they tested it and they subsequently cleared him, saying
Right.
that he wasn't the person.
Okay.
In this
It's the
case,
Samita case.
the Samita case, there was evidence. There was evidence of the sexual assault. There was DNA evidence. Samita was taken into court. He was being processed. There was a competency hearing going on. Joe Paulus received the crime lab analysis saying that he was not the person. He was innocent. Now, there had to be a false identification in that case, like the Avery case. But essentially what happened is that that report was just put in the file, never given. In fact, it was never given to anyone until there was what's called a Chapter 51 commitment, where he was going to serve a mental commitment, and the attorney for the county looked in the DA's office, found evidence of this, and said, wait a minute, we can't proceed because this person didn't do this. And that's how it came out. And in fact, in that case, I believe the judge said to the defense attorneys, if you don't report him to the authorities, meaning BAPR at the time, the Board of Attorney Professional Responsibility, I will. He was never reported.
You know, Mike, maybe I've been watching too many episodes of The Practice or Law and Order or something, but isn't it common for prosecutors to withhold certain evidence? I mean, that is a disturbing thing to contemplate.
Yeah.
But I can't believe that Joe Paulus would be the only prosecutor to do this kind of thing.
Well, see, that's why, in terms of the system, I'll tell you one thing is that, you know, as long as I've been a prosecutor, what we've done, or if I've done, is say, here's everything. You want it, take it. You get copies of everything. And that's the only way to do it, because you want to share your information. When you have prosecutors who hide information, that's illegal. That's against the law.
What is the motivation? Like this Samita case, however it's pronounced, what would be the motivation for Joe Paulus, or anyone for that matter, prosecuting a case, to withhold something and intentionally send an innocent person to prison?
Well, the only thing I can think of is that this is a high-profile case, a lot of media attention. You have people in the community wanting, you know, someone to be held responsible for this. You have the victim who says this is the person. So you put him in. And now you can say, well, the person who's responsible locked up. The problem is that in this case, in the Samita case, you actually have the perpetrator who was still out there. Now, we recently had a case very similar to the Samita case. It was a sexual assault that happened in Menasha. And the victim identified the person and said, that's the person. He was arrested. And there was probable cause to believe that he was, because, well, it was interesting because the DNA was sent down. We got a call from the crime lab. And they said, you know what, this isn't the guy. So what we did is we called the court that day and said, we want to bring this up in court. We got in court and we said, we want this guy released on bond. We don't have the formal report yet, but we've been told what's in it. And we think that to keep him in custody any longer than we can would be a miscarriage. So let's go. And it was interesting because in that case, the defense attorney didn't even show up. He was on his phone, and the judge said, well, can we address this later? And he said, well, you know, Judge, I have to go get a haircut. You know, and it ends up where we basically had to say, well, this is important. You know, your haircut can wait. And then, of course, the defense attorney made it sound in the press that, well, it was his idea that he get released, and that's fine, you know. But it shows you how, you know, there's two contrasting ways of handling the case. You know, I think the right and the wrong way.
Another of Paulus's motivations, I would imagine. I mean, we now know that this guy was chasing skirts all over the courthouse. I mean, we know this, right?
Yeah.
So he had. So
assumption.
So he had to have a tough conviction record. I mean, he had to have a public cover as a guy that was doing the utmost to keep everybody in Winnebago County safe, right? That allowed him to pursue his real goals in the courthouse. So it was a front, and it sounds like he didn't care if he had to put an innocent person or two behind bars to maintain it. Is that a fair assessment?
It seems that way. I mean, because you look at it, there's so many other cases, and you could go on and on and on. The one case that's in front of the Supreme Court right now is the John Maloney case.
I was going to ask you that.
Yeah, let's get
now,
to that one.
There's John Maloney, former investigator with the Green Bay Police Department. His wife, for the audience, I think you folks probably are familiar with this case, but his wife, there's a fire in the house. They are estranged from each other in the midst of divorce, weren't they?
Yes.
And there's a fire in her house. She dies, and you know, he's charged, tried, convicted, doing time in a state prison for her murder, and yet there certainly seems to be some compelling evidence to suggest that John Maloney didn't do it, and that it was, some people have suggested that she fell asleep with a cigarette burning.
Correct.
So I don't know, but yet he's tried to get a new trial one or two different times, and those efforts have failed.
Right.
But you've been looking at this, so what are your thoughts, Mike, on this case?
Well, some of the disturbing facts in terms of the Maloney case deal not only with the facts of the case, but the surrounding facts. For example, what's disturbing is that one of the last things Joe Paulus did when he left the district attorney's office is he had that case file removed from the district attorney's office. He wanted it so that nobody could see it whoever was coming in. So he had DCI, Department of Criminal Investigations, which is actually part of the Attorney General's office, take the file. They later turned it over to Vince Biskubic, who again refused to turn it over to our office and sent it to Brown County.
And Vince Biskubic used to be Joe Paulus's, was he the assistant, or was he?
He was assistant then deputy district attorney.
So he eventually was the deputy DA, and then eventually went on to, after Paulus groomed him, he went on to be the district attorney up in Outagamie County.
Right. And in fact, he tried the case with Joe Paulus. Then you start looking at the facts of the case. You have this tape that was done in Las Vegas, which occurred over, I believe it's 7 hours. And Jeannie Anthony from WHBY has looked at it, and what she found is that, number one, the original version of the tape was done. Then they did an enhanced version. Well, the enhanced version is harder to hear than the unenhanced version. Then she looked at the transcript and found that the transcript was erroneous. They had John Maloney saying things that weren't on the transcript. For example, there was one part where Tracy Hillenbrand, the girlfriend, says, "John, I'm going to go to the cops." And the transcript read, "Good, go to the cops." And what he actually said, in the unenhanced version, you could hear it, was, "Tracy, you know I didn't do it. Go to the cops." So, you know, there's a big difference between.
Sure.
That's a concern. You know, and why is an enhanced version worse off than the unenhanced version? Then you have the fact that the tape was sent to this forensic video, which is out of state in Minnesota. They sent back a bill for $27,000 for what Joe said was just to take little clips, admissions of John Maloney, and put them into one like CD-ROM. Well, $27,000 is a little bit high for that, I think. Later they reduced the bill to $5,000. You have those things. You have the fact that the sofa, one of the allegations was that there was an accelerant. Well, now it's been proven that basically the sofa cushion, it literally melts and will have a pooling effect. So it'll look like an accelerant. One of the DCI agents at trial had testified he did a test to show that that wasn't the case. Well, when asked for where are your records of the test, because when you do a scientific test like that, you videotape, you take still photographs. Well, his test, now you find out, consisted of taking a small little piece of the foam rubber and lighting it on fire. And it goes on and on and on. There's so many questions about it.
Okay, Mike, John Maloney has been saying for years that Joe Paulus ignored any evidence that would suggest that this was an accident, his ex-wife's death. And my understanding is the Department of Justice did an investigation very recently, and they were trying to determine if there was some manifest injustice in what happened to Maloney. And they concluded, unless I'm misinterpreting that report, they concluded no.
Yeah.
Well, what happened was that the person who was hired it was an independent person hired to do an investigation, which was Stephen Meyer.
Yeah, he was pretty thorough, wasn't he?
However, Stephen Meyer is Peg Lautenschlager's personal attorney. And he limited his report to one thing.
Which was?
Which was whether or not the autopsy report was correct. Because there have been other forensic pathologists, experts, who have said that this was not a homicide, this was a... So essentially his report was saying, you know, he went back to the doctor who did the autopsy and said, "Are you wrong?" "No." And he said, "Okay, that's it." In fact, he put in his report that I'm not going to look at the transcript, I've heard that there's inaccuracies, but I'm not looking at that because if it's a homicide, we don't care. You know, so it really wasn't and in fact, he said the reason why they didn't go further because they weren't given the funds.
Okay. Well, another claim that John Maloney's been making is that his attorney, Jerry Boyle, the Dahmer's attorney, infamous Jerry Boyle, that he got deficient representation, suggesting that Boyle and Paulus were in cahoots for a book deal, movie deal, and what have you. But my understanding is the state Supreme Court looked into that and concluded that, in fact, Maloney did not get deficient representation. What's your take on that?
Right. What they ruled is that there wasn't a deficient performance by the defense attorney. And then what the court did was they said, however, we're going to address the issue, basically two issues. Number one, should we, do we have the inherent authority to issue or to grant a new trial based on the injustice, manifest injustice? And number two is, should we? So that's what's being litigated right now.
Right now.
And that was interesting because at the argument in front of the Supreme Court, the Assistant Attorney General was asked, well, do you have any evidence? Can you tell us that the tape was not tampered with? And his response was, I don't know. Which is kind of interesting because you would think that, you would want to know that information. But I can see where a lot of appellate attorneys, they look at the record, they don't look outside the record. They look, and when you look at the standard, the burden you have to prove for ineffective assistance of counsel, it's fairly high.
Right.
So the issue is more or less whether or not there was a fair trial. Are there other issues that have come up? Because Maloney has several different aspects where he is saying...
Do you think Paulus and Boyle conspired together in this?
That's hard to say. I mean, it's... you hear all sorts of rumors, but you can't really necessarily say that, that's what happened.
But his innocence or his guilt notwithstanding, it sounds like, at a minimum, Maloney should probably get a new trial.
Well, that's one of the issues. And I've always said is that I don't know whether or not he did it or not. But did he get a fair trial? And I think the answer is he didn't get a fair trial.
He did not.
He did not, right. There's just too many questions that occurred. It goes on. And those things have to be looked at. For example, the tape itself. There's real questions as to whether or not the tape in Las Vegas should have come in, because the Las Vegas court ruled subsequent or around that time that that type of tape would not be admissible. And if that tape didn't come in, there would have not been any charges. There would not have been a trial at all.
Right. Another case, Mike, we'll finish with Maloney, sure. the case of Mark Price.
Yes.
Now this is where essentially... Well, why don't you explain the case to us? What happened with Mark
Price? Mark Price and Richard Pease, right?
Yeah.
Correct. There are two Mark Price cases.
Okay.
One, and I'll refer to one as the homicide case and one as the threats case. The homicide case was essentially the victim was Michael Fitzgibbons, and the allegation was that basically Michael Fitzgibbons was taken out to Lake Butamore. Richard Pease shot him in the head, gave the gun to Todd Crawford and to Mark Price, and that they both shot him. They put him under the ice, and that was the one where the body was cremated by order of then Coroner Stelter, and essentially there's a prosecution without a body.
Right.
From day one, Mark Price has indicated that he believes that, or he says he was innocent. Richard Pease, in a post-conviction motion, admits that he was the one who shot first. There's several things that are interesting about that case. For example, Todd Crawford, it was presented that he would be facing 5 years in prison based on his cooperation.
Right.
He was never charged with anything. Mark Price was convicted after a jury trial. while in prison, then there was an allegation that he was involved in sales of marijuana in order to get money to take a hit out on Joe Paulus. Well, those allegations came about shortly before the 1994 contested election that Joe Paulus had. In fact, the charges were filed, I think, within 2 weeks of the primary.
Right.
In that case, we filed some information because we found that, again, there was some information that was hidden. Joe Paulus appointed Vince Biskubic as special prosecutor to handle that case. There's notes in the file from Joe Paulus to Vince saying, I want you to subpoena this person, do this, do that, and basically controlling the special prosecutions, which you're not allowed to do.
Right.
We also found that some police reports were not handed over, tapes were not handed over to the defense. That one of the main witnesses in that case was basically offered a deal based on his cooperation. He got 5 years knocked off of his sentence. That was never communicated to the defense. In fact, they never even put that in the file. The defense attorney found that out by going to the Milwaukee County District Attorney's office, getting a copy of their files, where you had a letter saying, this guy's been very cooperative, let's give him 5 years off for being such cooperative. And what's interesting about that is there's another where a co-defendant, Terry Magnum, who was supposedly arranging these pot deals, it was indicated that she was going to be pleading to a felony. She was never charged. Sort of like Todd Crawford, sort of like, you know, some of the other cases. So as we talked about patterns, you see patterns developing.
Well, here's what I don't understand, Mike. It sounds like your office found out lots of information about the Mark Price case, and yet Judge Scott Wolt took it out of your hands.
Right, he took the homicide case.
The chief of police, Erickson, said he had grave concerns regarding the current review of Mark Price's conviction for murder. He said the process is potentially flawed because of possible bias by the reviewing prosecutor.
Right.
How did you guys feel about that? He's essentially Lennon, and I guess you also, did not have the proper amount of objectivity to look into this.
Right. You know, part of the problem, I think, is that if you look at it, we handled the motion hearing on the Richard Pease case. And Chief Erickson didn't write a letter on that case.
No.
And what happened was that we basically objected to that motion because of the fact that we said that, you know, essentially he admitted to it. Now, I don't know why Chief Erickson didn't write a letter on the Pease case, but he did on the Price case. And I think part of that is that, you know, Joe Paulus would always say, okay, this guy's the nastiest person in the world. You know, we've got to get him. And then you look at Joe Paulus was making a deal with, tried to make a deal with Mark Price. After John Maloney was convicted, he said to Mark Price, you know, if you get John Maloney to basically say that he wants a contract out on me, I'll get you out with time served. Now, it's kind of unusual that, you know, here's a person that you've demonized, and now you've said, oh, hey, by the way, make a deal with you and you get out.
Well,
you know, it's...
Mike, let me ask you this. I mean, it just sounds like this stuff could go on and on and on. And with 14 years in office, Lord only knows the stuff that Joe Paulus could have done. And we'll probably never know the full depth and breadth and extent of this whole thing. But long story short, if people are in prison or have been imprisoned unjustifiably, illegally, because of things that Joe Paulus and his cronies have done, A, what recourse do they have, and against whom? And secondly, kind of a dovetail of that question, can Paulus and other parties associated with him in this illegal prosecution, can they have charges brought on them, or is there a statute of limitations on stuff like that too that would have probably told by now?
Okay. Number one is that if a person feels that they've been wrongfully convicted, we've looked at many of those cases. Some of them we have found problems, some of them we have not. So we will review that. There's also, I know that the Innocence Project down at the University of Wisconsin, they have taken some cases because they believe that there's problems. So that's another option. Statute of limitations, as I said before, you know, normally it's 6 years. However, with a racketeering charge, it can go back. So these people who may have thought that they covered their tracks, they did all the things that they could to prevent being caught, they can still be prosecuted. The question is whether or not the Attorney General's office would allow that to happen.
Okay.
Right.
So where are we at with the Paulus thing right now? I mean, with your office's investigation, where are things right now?
Well, we're still proceeding. We're still uncovering more cases. We're still trying to get more cooperation from the Attorney General's office.
Right.
We probably have a list of, I would say, more than 30 cases that we believe that were bribery cases. We're uncovering more every day, or maybe not every day, but every week we find something else.
Because people come forward, or
People come forward, and plus also it's a painstaking review of all the records, and we're doing that.
all right. Let's. Oh, I'm sorry.
Yeah.
Let's talk about Vince Biskupic for a little bit. Now, he was Paulus's deputy.
Correct.
He then became Allegheny County DA.
Correct.
You worked for him in Allegheny County.
Yes.
You were an assistant DA.
Yes.
All right. And he ran for Attorney General against Peggy Lautenschlager.
Correct.
Lost that race. You actually said, now one thing he was famous for was this fund, this victims fund, correct?
Crime prevention fund.
Right, where so you didn't go to jail, you paid money into a fund, right?
Correct.
And you said, I, meaning you, was instructed to make an offer to all of these guys. If you come in and pay $5 grand, there would be no charges.
Correct.
You did that.
Correct.
Okay, you would tell that to the defendants, that if they pay $5 grand, there'd be
Oh,
no
no,
charges.
that was actually, what you're talking about is actually, there was a lottery case.
Right.
Schoenfeld was the name of one of the defendants. There was William Mose was the main person. And basically what happened is that that case was referred by one of the judges for perjury.
Mm-hmm.
And what happened is that Vince Biskupic said, well, this is the offer on all the cases. You know, donate $5,000 to the Crime Prevention Fund, you'll get a deferred prosecution agreement.
But you were the one that had to tell these guys for okay.
Correct.
Right. But it wasn't until after he left the office that you came forward, right, and said that this was improper.
Well, what happened is that there was discussions of whether or not that was appropriate. At that time, what happened is that that was an appropriate, in terms of, that was legal.
Mm-hmm.
Subsequent later is that the legislature said you couldn't do
Right,
that
but
anymore.
but at the time you were working in that office, you must have felt that it was improper.
Well, I didn't think that it was right because I thought it was, you know, people buying their way out.
Right.
In the lottery case, it was a little bit different because I thought that what you're trying to get at was these guys won, I think it was like $100,000 and 10 guys split it up. So what you were trying to do is say, okay, I'm taking away all of your money, essentially.
Mm-hmm.
You know, so that was, whether it be by a fine or whatever, that was probably, you know, I thought it was, you know, sort of like you get what you know. So, and in fact, in one of the cases, it didn't go to the Crime Prevention Fund. It actually got a $5,000 fine,
Sure.
which was a, you know, huge amount.
But do you feel that Biskupic did overall abuse that crime prevention fund?
Well, I think that's
Was he making like calendars for it? Somewhere I think you said he was collecting money to get a van or something like this.
Yes, yes. That was one of the things that happened where he was trying to get a van. It ended up where he didn't get that, but he still had the money in the account.
Okay.
They actually got a van from a different area.
All right, and he also was obviously an integral part of the Smart Price case, correct?
Correct.
And I think you did say in the State Journal that Biskupic's actions were an abuse of the justice system of the worst kind. That's a pretty strong statement.
Yes.
What did he do that was an abuse of the justice system of the worst kind?
Well, you know, if you look at the Mark Price threats case, and that's the case we're talking about, we filed, I think it was about a 40 to 50 page document dealing with that. And what it showed was that, for example, that he didn't turn over police reports, that tapes weren't given to the defense attorney, which were exculpatory in nature.
Okay.
One of the tapes was a tape between an undercover officer and this Terry Magnum, where the undercover officer is saying, well, I heard your guy, meaning Mark Price, wants to get a hit, basically, on somebody. And she's like, well, I haven't heard that. I'll ask him. The next tape, she's saying, you know, I talked to him and he thought it was kind of weird. He doesn't have any idea what you're talking about. Well, that tape was never turned over. You know, so you go on and on in terms of the fact that he shouldn't have been handling that case, especially in light of the close relationship between him and Joe Paulus. He was Joe Paulus's best man at Joe's wedding.
Right.
During that case, there were so many differences, you know, so many problems with that case that, you know, you go and look at all the details and you see that basically it looked like the purpose in filing that case was to get Joe Paulus reelected.
Right.
It got him reelected and it served its purpose.
Okay, it sounds like you think that Biskupik should be behind bars.
Well, you know, there's a difference between criminal actions and ethical. And I think that that's something that, unfortunately, the Office of Lawyer Regulation will have to decide.
Right. But the Attorney General's office isn't moving on this.
I don't believe that they are.
Yeah. See,
doing
what's going on there? I mean, if a person who worked under Biskupik, who's now a DA running an investigation, says that this guy did something that's an abuse of the justice system of the worst kind, unless they're flat out refuting what you said, which it sounds like they haven't done that, why aren't they moving on it?
Well, the only thing I can think of is politics.
What's the politics here?
Well, the only thing I could think of is that, you know, Vince Biskupik ran against Peg Lautenschlager last time, and it might look bad for her to go after her former opponent. I mean, I don't know if that's it or not. You'd have to ask Peg Lautenschlager and the rest of the people in the Attorney General's office.
We probably should invite the Attorney General in, because
that wouldn't be a bad thing to do. We've got some questions for her. We want to shift gears here real quickly in the remaining minutes that we have. We're down to probably about 7 minutes. You had recently provided some information to Tony, and subsequent to that, it's on both of our websites, about Winnebago County Judge Tom Gritton, who is being substituted left and right on cases. And just so folks get a sense, if you haven't seen the websites, between January 1st of 2000 and the end of 2004, there were a total of 1,412 judicial substitutions in all of Winnebago County. Of those, Judge Gritton personally had been substituted 1,025 times. Now that's a lot. I don't expect you to speak for Judge Gritton, but what kind of...
But tell them, Cheryl, that the next closest was what?
Well, the next closest was Judge Key with 98. So that gives you a sense of what's going on here. But I guess, why is this going on? And what does this do, Mike, to, you know, these other judges? I mean, how much additional burden does it put on the other 5 judges in this county when you've got a judge being substituted this many times? And who's asking for the substitutions? Is it the defendants? Is it the judge himself? Because prosecutors don't get to seek substitutions, do you?
Correct. We can't seek any substitutions. Under the statute, a defendant has a right to substitute a judge once.
Okay.
So they could substitute before the initial appearance on a misdemeanor, or before the arraignment on a felony case. So that's what you're seeing, is those type of numbers that people are saying in both criminal and civil cases. You know, I don't want to be in front of this judge.
And the judge himself can ask for a substitution to recuse himself?
The judge can recuse himself if there's a conflict, you know, knows one of the parties, knows a defendant or something like that. that can happen also.
Is it your sense that most of these substitutions are defendant requests, or are some of them Judge Britton himself?
The majority are, I would say, maybe 99%.
Well, what's the buzz around the courthouse, Mike? I mean, I imagine you must talk to lots of defense attorneys. You must know of lots of defense attorneys who've requested a substitution. What reasons do they give reasons privately?
Well, you know,
they don't have to give a reason publicly, right?
Correct. And you know, I think that part of it is that you know, just that they will never, you know, defense attorneys won't come out and say, you know, something like, I believe the judge is unfair or anything like that. They let the numbers speak for themselves. Yeah. And that's what you have here. The numbers are speaking for themselves. When you look at it, you know, the judges, you know, it's not that, you know, he's so tough or whatever, because Judge Key is a very good
tough
judge, and then she's a tough judge. She only has 98.
Yeah.
So it just indicates, I think, to me that, you know, there's a problem, and it puts the burden on the rest of the judges, because they have to take up the rest of the slack.
So they don't, if Gritton can't hear a case, they don't bring in like a reserve judge then?
Correct.
Okay.
Because under the substitution rules is that it goes to the court administrator or the chief judge, and then chief judge reassigns to another court.
Well, I can't imagine that these other judges are any too pleased with this kind of substitution rate.
Hey, you should probably talk to the other judges about that.
We're down to 2 minutes.
Just want to ask your opinion. There's another lawyer, Richard Bolenbeck,
Yes.
from Appleton. He apparently may be one of the attorneys that was making payments to Paulus and so on. Where's that case?
Well, that's under investigation. There was the Melinda Otto case.
Right. She was a client of Bolenbeck's.
Correct.
Who claims that he said if she paid $5 grand, she could get a reduced sentence or no jail time.
Because of his ties to not only Paulus, but to Judge Gritton.
But Gritton, right.
Right.
Which
So
is disturbing also,
right.
if
Where's
that in fact
that
happened.
right now?
Well, that's been referred to the Attorney General's office. We did have a motion hearing on that case in front of Judge Haase, where Rick Bolenbeck was asked whether or not he had paid any money to either Joe Paulus or Vince Biskubic.
He took the fifth.
And he took the fifth. And you can only take the Fifth Amendment if it will impact you in terms of a criminal investigation. So I believe that is being looked at by the Attorney General's office, and we're waiting to see what they do with that.
Okay.
Well, the saga continues, doesn't it?
Oh, yeah.
Well, keep us posted, Mike, on what's going on, and you know, thanks very much for being here. We appreciate you taking time out of what I'm sure are very long days.
Oh, yeah.
Not just investigating the Joe Paulus stuff, but putting away the bad guys, or at least trying. So thanks very much for being here. We appreciate it.
Well, thank you.
And thanks to you, as always, for joining us and letting us into your homes. We'll see you next time. Tony, thank you. And until we meet again, take good care. Keep your eye on us. We've got our eye on Oshkosh.